Amendment proposed in clause 1, page 1, line 6 at the beginning. Insert the words as printed on the marshalled list.
I have added my name to Amendments 1 and 21 in the name of Lord Clement Jones and Baroness Ducey, which have just been moved so well. In fact, I think I agree with all of the amendments in this group, although I'm not quite sure and have some reservations about Amendment 2, but on lowering the age to 16. But the proposition, it seems to me, is straightforward. The powers to tackle antisocial behaviour are currently contained in the Antisocial Behaviour Crime and Policing Act 2014. So before the state even affords itself even more powers, often, by the way, that duplicate what we already have, shouldn't we assess whether what we have actually works in terms of improving outcomes for victims and fundamentally reducing antisocial behaviour, which is what we want? We should note that 82% of antisocial behaviour practitioners surveyed by Justice have called for such a review of existing powers and criticised the lack of proper consultation or even engagement with the government. And I do think it's shocking that there's never been a formal review of the 2014 Act, and that data on the use of existing orders is not collated centrally and nor their use monitored by government. So surely the Minister agrees that the government should be working to identify and address problems inherent with existing antisocial behaviour powers and orders before creating more, and that would be an evidence-based approach to this question. We are focusing on respect orders largely in this group. They are almost duplicates of antisocial behaviour injunctions, which the government has argued will provide more effective enforcement. Actually, experts and practitioners suggest that they could actually confuse enforcement agencies. And what's more, as respect orders are so close to ASBIs, the fear is that they will just reproduce and increase the problems with those injunctions, which research show are overused and inconsistently applied, and sweep up relatively minor behaviour problems alongside more serious incidents. At the very least, can the Minister explain why the discredited ASBIs are staying on the statute book? Why not just dump them? If, as the government tell us, the key difference with respect orders is to deal with persistent and serious antisocial behaviour, then that should be made explicit in the legislation. Otherwise, the danger is they just become another overused part of a toolkit handed out promiscuously. And that's a particular concern because of the government's use and the bill's use of the phrase that these orders are just and convenient. Now, that word convenient is chilling, because here's the rub. Respect orders are formally civil orders, but essentially criminal in character. And I think, as the noble Lord has already explained so well, that I'm worried about this conflation of civil and criminal in relation to respect orders. The government is removing that rather inconvenient problem of a criminal standard of proof, because it's got all that tiresome beyond reasonable doubt palaver that you have to go through. But if you're found guilty, as it were, there is a criminal punishment doled out via a respect order, and you can, as we've heard, receive up to 2 years in prison, which does rather contradict, by the way, some of the emphasis in the sentencing bill of trying to actually stop people going to prison and keep them in the community. So it's not entirely joined up government either. A second reading, I quoted Dame Diana Johnson, who made this convenience point very clear by explaining that the problem with a civil injunction, such as an ASBI, is that if breached, quote, the police officer has to take the individual to court to prove that breach, as though somehow that was a real problem. And she complained there is no automatic power of arrest. Now, that bothersome inconvenience has been overcome by creating a new respect order, which Dame Diana enthusiastically states, quote, combines the flexibility of the civil injunction with the teeth of the criminal behaviour order. And I think that that sort of convenient mashup of legal solution is something we should be very wary of. It's also got a dangerous precedent that shows that a cavalier attitude to legal norms and justice can lead to great injustice. I was thinking when I was reading all this of the single justice procedure, which we were told would allow public authorities to bring cheap and speedy prosecutions for law breaches such as not paying the BBC licence fee or dodging transport fares. But with quick prosecutions conducted in such a way, and in that instance behind closed doors, as I think exposed brilliantly by Tristan Kirk, a journalist at The Standard, we've seen thousands of people on an industrial scale being found guilty, often of small unintended mistakes. And I do think that we just have to remember that if you try and bring about justice quickly and using these new methods, you can actually cause huge amounts of problem. There's harrowing stories of people who are very ill, people who have dementia, even people who've died, who've been victims of these single justice procedure issues. And so I just hope that the amendments in this group will recognise that fast-track systems of convenience actually can lead to some terrible unintended consequences. And I'm also reminded, in a similar vein, of the growth of those monstrous non-crime hate incidents, again a legalistic mashup, which have caused so many problems for free speech, using paralegalistic language and confusing us over what constitutes guilt. And so I was glad to see the Noble Lord Ben Catherine's amendment in this group and look forward to his comments later. So I just think this group of amendments is one that I really would like to hear the Minister respond positively to. They're well-intentioned, nobody is being dismissive of antisocial behaviour, but we do not think that these particular orders, respect orders, are fit for purpose. And on the other hand, antisocial behaviour orders in general are in a mess, and at least let's review what works and what doesn't work before we move forward.
Lord